So good morning and welcome everyone, and thank you for attending our session today. I'm Fiona Omar and I'm the content manager for Practical Guidance, which is our legal how-to platform at LexisNexis. So today we are going to be discussing POPIA and the rule of law. So in other words, how POPIA's principle-based approach compares with the requirements of legal certainty and predictability that is required by the rule of law. As we know, POPIA is set within a context of a continuously and rapidly changing information landscape, and regulation and enforcement of POPIA requires quite a flexible approach. But it is also important that legal certainty is established wherever possible, particularly as I think that more POPIA cases make its way to the courts. So just a few housekeeping rules for today. I just want to make sure everybody can hear me properly. As you can see, we have got our agenda that has been set out. So just to go through a few housekeeping rules for today. As you know, all delegates will be muted for today's session. However, we have a Q&A tab and we encourage all participants to please post your questions and we will try to go through as many as we possibly can. Also, please do note that all delegates will get a copy of today's webinar that will be available to them. And so without further ado, it gives me great pleasure to introduce and welcome our guest speaker for today, Advocate Nicholas T. And of course, he is an advocate of the Johannesburg Bar and is incredibly passionate about POPIA and all things that is data related. He also has interest in land reform and land claims, and together with Advocate Ismail Hussein has co-authored the norms and standards. So over to you without any further ado, Advocate T.
Thank you, Fiona. Good morning, everybody, and thank you for spending your precious time in November on a webinar, because I know people are starting to get stressed to get the work out before the end of the year. What I'd like to do to start is that I would like to acknowledge the work of Professor Martin Krieger, who is a professor at the University of New South Wales, Sydney. The pronunciation of his name, I presume, is Australian, but I'm going to spell it for you. It's spelled K-R-Y-G-I-E-R, but he calls himself Krieger. And you will see why I need to acknowledge him when I start the actual first slide. And I'll tell you why I'm going to do the rule of law in relation to POPIA in two phases. If you can put on the first slide, Marilda. Okay, there you are. It's the state of the law, the rule of law globally. I want to make some comments about this, that it's very important to conceptualize. The first thing I'm saying is that there are practitioners registered with the Legal Practice Council in practice as attorneys and as advocates with trust accounts. But I'm going to be placing an enormous amount of the focus of what I'm doing today on the people who are technically on the non-practicing role. Those are the in-house counsel all around the country. Those are the people who have to give advice to their bosses concerning the implementation of POPIA. And the reason why I'm doing that is because at the moment, the state of the rule of law globally is in a bit of a mess. Luckily, South Africa is not the worst if you see the map, but we're certainly starting to slide down. In fact, this is from the World Justice Project, this slide, and you will see that the blue, the dark blue, represents the best form of the rule of law at the moment. And then the colors start going through to orange, and of course, Russia and is worse off even than China. Now, South Africa, in terms of this index, has slid, unfortunately, into the light yellow, even though Botswana and Namibia have not. So this map is a little bit more informative, positive, I should say, towards South Africa. So let me explain why there is a problem with the rule of law, and I'm going to deal with it in general terms, and the reason is very simple. I don't want to get bogged down in the philosophy. I want to get to explaining how it works with POPIA. The essential problem that is going on with the rule of law is that there is a constant carping all around the planet against democratic institutions and democracy. And the rule of law and democracy are very closely linked, although the rule of law is much older than a modern democracy. The rule of law can be traced back from Aristotle through Bracton, all the way through Montesquieu, right into the modern era. And one of the reasons why, and we're going to deal with this at length later, one of the reasons why the rule of law is under attack, because democracy is under attack, is because it's not well understood by the lawyers who are the practitioners themselves. So if we move to slide 2, I want to highlight why I'm saying that. Lawyers have a very limited concept of the rule of law, even though we are the ones who are supposed to be dealing with the rule of law day in and day out. In the quotation from the Pharmaceutical Manufacturers Association, which was done by Chaskelson when he was still president of the court, I don't know if practitioners might remember that in November of 2001, the president of the court was changed to the Chief Justice, and then the president was moved to the Supreme Court of Appeal. So those appellations were changed in November 2001. And here is a quote from that case where Chaskelson quite correctly was saying that the scope of the rule of law is broad. That's true. It's managed to justify, he says, albeit not always explicitly, a great deal of specific content of judicial review. And there he's referring back to the apartheid eras. And what is that? That orders of court should be obeyed, that individuals wishing to enforce the law should have reasonable access to the court, that no person should be condemned unheard, that power should not be arbitrarily exercised, and I'm going to come back to that because that's the essence of what's going on in the rule of law. In addition, the rule of law embraces some internal qualities of all public law. Okay, and then it comes to the usual ones. The law should be ascertainable in advance, should be predictable, should not be retrospective, should be applied equally and without unjustified differentiation. Now, when I move to the next part of this slide, if you move up, I will show you exactly why I'm talking about this. We need to ask, most importantly, what is the purpose of the rule of law? Now, if we do not understand the purpose of the rule of law, then we can never apply it even if we've got the best checklists in the world. The purpose is to use power properly, and let me explain what I mean by that. Power is a feature of the way human societies are organized. It does not matter whether that is an autocratic, democratic, dictatorship, oligarchy. It doesn't matter. Power is used at every level of all features of society. So you get power in church institutions. You have the power of the Catholic Church. The number one there, and the joke is always, is the Pope Catholic? That's the joke. Why? Because obviously he must be Catholic. He's the Pope. So there's power in every institution throughout society. So what is the purpose of that power? It is to use it properly. So if you slide into this slide a little bit deeper, you will see that the real purpose is to be able to deal with it properly under the constraints of government, in the absence of corruption, fundamental rights, order and security, regulatory. Now, all of this, everybody knows who's ever touched on the rule of law. But there's one aspect which is not being highlighted here, is how much of the rule of law is needed to be applied properly in the private sector. Lawyers tend to think that the rule of law is something that is only for government, but it's not. The rule of law is throughout the society. And the real purpose of that, you can move the slide now again. The real purpose of that is once you've got this understanding that you have an equality under the law, a transparency, an independent judiciary, accessible legal remedies, which gives you the rule of law, what is the purpose of the rule of law? The purpose is in the next slide. You can go through that one as well. I'm speeding up. These ones you all know. You can show all of these. Everybody knows that you've got to be careful, you've got to have equality, you've got to have transparency, you've got to have an independent judiciary, you've got to have accessible legal remedy. Now, what is the purpose? Put it into the next slide, please. There it is. The purpose is to temper the arbitrary exercise of power. And this is where I want to talk directly to those in-house counsel all around the country, to those people who are advising and have the terrible job of having to talk to very difficult bosses. If you are a lawyer and you're on the non-practicing role, you are subject to the code. Now, I haven't put this into your documents, but I'm just going to read it. Part 7 of the Code of Conduct of Legal Practitioners Not in Private Practice, Section 63.2 reads, corporate counsel must at all times act in an ethical manner and should, without limiting the general nature of this duty, adhere to the following standards of conduct, and obviously to act fairly and honestly and transparently, but the one I'm focusing on is 63.2.2, remain impartial and objective and avoid subordination or undue influence of their judgment by others. Now, that means that when you read POPIA and your boss wants to do something which you think is against POPIA, you've got to stand your ground. You have got to be ready to get fired. Unfortunately, your job is even more difficult than the practitioners in practice. Because the practitioners in practice, they give advice and then they run cases, and advocates, good advocates, they run their cases on the instructions of what the attorneys give them, but they don't care for the result. They care that the process is correct. And at the end, they care that justice is done in terms of the Constitution, but they are not personally involved in whether the client wins or loses. In fact, the very good advocates, the really good ones, have a 50-50 success-failure ratio. Why? Because they are so good, they get briefed by the top firms, and they get briefed in difficult cases and in relatively easy cases, and they will win or lose depending on the facts of the case. Because there's something else that everybody needs to know, and good lawyers know this. Facts first, law later. So now let me explain some more in this. When I'm talking about all levels of where power is exercised, let me give you some examples of sad cases where power is abused. There are places in society where power is abused by people staying on boards longer than they should. There are people who stay on boards in parents' associations at schools longer than they should. There are people who stay at SAFA longer than they should. You've got it. I think anybody would exercise. That is an abuse of the rule of law, because you're not tempering that arbitrary. Once people get ensconced and they keep others out, that abuse happens throughout society. Now, we have a sort of shorthand term that we use in law. It's called keeping the turf. So you want to keep the turf. You want to keep your clients. You're a big law firm. You'll only brief your favorite advocates. You will never spread. And God forbid you brief junior black advocates. Why? Well, you don't know them. Think carefully, people. That is a form of an abuse of the rule of law. So the last point I want to make, in that line, you'll see while lawyers, including judges, abide, we've got to temper it even for lawyers getting the rule of law right. And I can tell you now, if you speak privately to lawyers who are in practice, particularly attorneys, you will see how they fret and are angry about a stream of directives that come from the judges. Some of those directives are regarded, rightly or wrongly, as whimsical. But that is where judges are not actually themselves abiding by the rule of law, because those directives do not explain why they're moving away from the uniform rules of court. If a lawyer, be that an attorney or an advocate, is qualified to practice in Thohoyandou, which is now a provincial division, at least a local division of the High Court, that lawyer, attorney or advocate, should be able seamlessly to move to Cape Town, Johannesburg, Pretoria, without having to learn an entire new set of rules. That's the rule of law. Okay, let's go to the next slide. Now, I want to say something about POPIA in itself, because POPIA is principle-based legislation. I'll give you an example of what is not principle-based. Section 29 of the Basic Conditions of Employment Act is not principle-based. It's a checklist. So the common law, for example, under labor law, the common law has always been, you do not need a written contract of employment. You can have an oral contract of employment. But if you have an oral contract of employment, you have to have everything that is listed in Section 29. So you might as well have a written contract, but you don't need one. But there's the checklist. And so when you've got your contract, you check it off, tick, 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 down. POPIA is not like this. POPIA, the key word in POPIA, the one which makes human beings fret the most, is the concept of reasonable. And I'll be going through that later when we hit the POPIA. I'm going to go through a selection, my selection of some of the fun parts of POPIA. Obviously, I'm not going to do the whole act today. I'm going to isolate certain sections and deal with those. But reasonable means that there is a balancing to be done. And when you do the balancing, unfortunately, it doesn't fit into a checklist. It fits into using your mind to debate with your colleagues and your co-workers and your bosses and the people who work for you, what is the most appropriate way to apply POPIA in a particular circumstances. So checklists are still important. I would say the checklists have the importance of a precedent, but better than a precedent is a template. Now, the reason why I say don't use precedents, do not use precedents for anything except if you're using it as a checklist so that you haven't missed something. Because what often happens is that the names of the parties are left in the wrong document. Even, forgive me for pointing this out, the original Code of Conduct published by the Legal Practice Council was published under the Cape Law Society rules instead of national, and they had to change the name. So this happens when you use precedents. So checklists are like precedents. What you want are templates, and then you will be able to understand the importance of why you need to check that you've got everything, but not rely on the checklist. You rely on your own mind. So I want to go back to, if you can carry on to the next slide, please. Okay, that's right. Now, we need to go back to the basics here. How does POPIA fit into the rule of law where lawyers are looking for certainty? They want things to be ascertainable in advance. They want to be predictable. And particularly those lawyers who are in private, who are in-house lawyers, your boss gives you something and says, what is, for example, Section 19, which we'll deal with later, of POPIA mean? And you have to apply your mind to that to explain it. And I will go through Section 19 later, not quite yet, to explain why it's so important. Now I want to make a very controversial remark. And you can take it with a pinch of salt, but it's very important. A very considerable part of the way lawyers behave is to use process over merits. Hence, we have the abomination of the Stalingrad defense for Jacob Zuma. That is a complete violation of the rule of law. That is using the process of the court to defy the judges. That's an abomination. That is wrong. I want to say something else that is also you can take with a pinch of salt. Most importantly, the concept of risk management must not be risk aversion. Let me repeat that. The concept of risk management must not be risk aversion. Risk aversion is cowardice. It means you don't want to take responsibility. So you're passing off the responsibility to somebody else. I think most people will probably accept that far of the point I've made now. But here's the rub, and this is the difficult one. When the party with power in a contract requires the weaker party to indemnify the powerful party, you are violating the rule of law. Then you have moved from risk management to risk aversion. That's wrong. That's a violation. And that's a violation across the board. Whether you're in private, public, that's a violation in the churches. That's a violation in the schools. That's a violation in government. It's just wrong. Don't do it. But it means that you do have to think. You have to apply your mind. How do you get proper risk management? Because you have to manage risk. And one of the best ways in which risk is managed is obviously through insurance. But if you are passing it off to the other party, the weaker party, then you are violating the rule of law, because what you've done then is you are abusing your power. You're not using your power. So those are the two main controversial remarks I want to make. So then let me move into the more dedicated parts on the next slide. Okay, now you know that POPIA is a balancing act, and I'm going to be using my own script here because I've highlighted what I want to concentrate on. The constitutional right to privacy has justifiable limitations, which you'll see there. Its privacy is set off against access to information and protecting important interests and the free flow of information. So if you want to understand where POPIA fits in, POPIA is the structure where we balance the competing interests of people who want privacy and the important need to have a free flow of information, including personal information, to keep the markets moving, to keep trade flowing. That balancing act has to be done virtually at every level. And that is why be careful of those people who say, we are 100% POPIA compliant. They're lying. No one is. Perfection is not the realm of this planet. There is no perfection in this planet. There never was, there never is, there never will be. Perfection is for the afterlife. In this world, you can never be 100% POPIA compliant. Don't even try. The key there is, remember the word reasonable. So I want to highlight B. This act is to regulate the manner in which personal information may be processed. And the reason why we do the manner is because it is the manner, it's the way we do things that is more important than the end. You've often heard the end justifies the means. That is for people who violate the rule of law. That is for people who violate power. Ask Vladimir Putin. He thinks he can violate international law because he's peeved with NATO. But in the process, he's killing people. That's a violation. He knows it. We all know it. All honest human beings know that, even the supporters of Putin. Now, let me go to the next one. I want to show you how this act must be interpreted, which is section 3.3. This act must be interpreted, obviously, to deal with those points in section 2. But now I want to show you the most important feature of 3B. This act does not prevent any public or private body from exercising or performing its powers. In other words, the real tragedy of our municipal government is that people are employed to do work, but they are so scared of carrying out their work that they might get into trouble that they don't. So municipalities have to hire consultants. So the taxpayer is paying twice for the same job. So this POPIA Act is not one of those acts which says you get employed to sit and in a municipality and work on your cell phone, on your smartphone. You get employed to do your job, but you must be able to do your job. And perfection in doing that job is impossible. What you've got to be able to do is do your job well enough that you can comply with the reasonableness test. And you've heard the word reasonable again. Okay, let me go to the next one. I know I'm going a bit fast, but I just want to point out a few things. In section 7.2, one of the most important and potentially dangerous abuses of the rule of law is contained in the words exclusively journalistic purposes. Now, journalists have often been regarded as the fourth estate. A free press is absolutely vital to a democratic order. But you know, and those of you who are advisors to journalists or advisors for people who've been affronted by the journalists, have got to work out whether in the application of the rule of law, particularly under Section 7.2, was the journalist using the power given there or abusing the power? And this is why it becomes so difficult for people who are Fox News adherents versus people who are CNN news adherents. And I'm using foreign so that I don't get into trouble in South Africa. I'm using foreign examples. But you can see this, a tremendous divide. Now, the way through that conundrum for people in private practice and people in the law, you know, legal practitioners, advocates and attorneys, is just be focused, facts first. If the journalist has got the facts right, then you're relatively safe. If the journalists have got the facts wrong, then you're not safe. And that's where Hofstadter, I'm using a South African example, got it badly wrong about the rogue unit in SARS. That's a mistake, that's an abuse of power. There's a practical South African example. Okay, let me move to the next one. I'm not going to be dealing with, you can go to the next slide. Now, here's one of my favorites, Section 19. Now, in my opinion, Section 19, for practical purposes, is probably the linchpin of the modern application of POPIA, and it certainly, it represents a very good summary of the recitals and the articles in the GDPR, the General Data Protection Regulation. So this clause is critical to understand. And I want to highlight in this clause the most important phrase in this clause. It's in the second line of Section 19.1. And I'm just going to read the words. You've got to use appropriate, reasonable, technical, and organizational measures to prevent. Now, let me focus on those. Appropriate, okay, that's a general word, and it depends very much on the circumstances of a particular case. That's why we use the word appropriate, because it allows a wider scope. Reasonable, technical. Now, this is where it becomes more fixed. When you're dealing with security safeguards, the most important thing to take away from today's webinar, you are not required to defend yourself like a Fort Knox. That's unreasonable because it costs too much. You would bankrupt your own organization. You have to do what is reasonable. And in the organizational measures, I'll deal with that a little bit lower because the second part of Section 19 that I want to emphasize, it's very important. It's Section 19.2a, just the first part. You've got to identify all reasonable, reasonably, again the reasonable, foreseeable, internal, external risks. Let me deal with the external risks first because it's relatively easy. The external risk does not mean that you have to prevent a zero-day attack. You do not have to prevent a zero. Nobody can prevent a zero-day attack. But you have to have the most up-to-date manner of looking after your data, be it electronic or on paper, particularly for poor conveyancing attorneys. A lot of their stuff is still on paper. And if you deal with the master's office, it's all on paper. None of that has been, well, it's going to be digitalized, but it's not yet. You have to have a reasonable understanding of your external risk. Once you've done that, even if you get hacked, there are ways to deal with what happens after the hack. You have your plan, you publish it, you inform the Information Regulator. I want to focus on the tragedy of the first word in that line there of the two risks. The first word is the internal risk. And here, alas, I know there are people from the banks. This is where the banks fall down the most. This is where the banks are at most risk, because they're not actually identifying accurately the internal risks. So what happens in the banking sector, which is, it's frustrating and sad. What happens is that the banks feature clients. And it happens that inside a bank has two featured clients, A and B. And B steals the money by hacking and puts it into, B stands for, I don't think it's appropriate to say it, but you know what it means. B steals the money of A in the same bank, and the banks don't stop it. I would like, personally, this is the third very contentious thing I'm going to say today, I would like to see the FICA Act changed that where it happens inside a bank, between the same client, between two different clients of the same bank, that there should be strict liability. That the bank should immediately pay back the innocent and then go after the guilty, the one who stole. But that's not the law at the moment, but I can tell you how people can deal with that. What you've got to do in the banks is that you have got to take an approach that believes the client first. Not, in other words, if you are using your power as a bank, and banks have got immense power, vast power, way beyond 99% of ordinary human beings. Banks have immense power. If you are using your power in accordance with the rule of law, you look after the interest of your client first, the one who's been hacked. You do not put up walls of defense saying, oh, you must have let somebody get hold of your PIN. You must have given it so. Then you are bullying your client. Bullying is a violation of the rule of law. So banks, please, I beg you, step up to the plate. I know it's hard. You do need to know that your Achilles heel is on that word internal, and that is where the litigation will swim around you in the future. Okay, that's enough. I don't want to deal any more with that. I see I'm running out of time. In fact, since I have basically run out of time, I would like, Beryl, I'm sorry to do this to you, if you could push through the slides slowly. People, when you look at what I had there in the slides, please just note on your paper, section 21. When you read it, you'll see why I had it there. Go to the next one. You will note why I had it there, 37. I just have to say something about 37 before we disappear. In this, you can ask the regulator to grant you an exemption. When you ask for the exemption, formulate the exemption so well that the regulator's answer to it is, my word, that makes sense. do not, in other words, it's like drafting an order of court. The rule for an order of court is very simple. Draft an order of court, which you're going to hand up to the judge or to the magistrate, so that the presiding judicial officer will say, this makes eminent sense. Now, you will recall the FETA case against the minister concerning tobacco products a number of years ago. If you go and look at, you only have to read one paragraph. It's on the internet, it's on Safely, it's anywhere. You only have to look at paragraph 2. There are 3 judges of the High Court, and they mention prayer 1 in the notice of motion. And in prayer 1 of the notice of motion, the 3 judges of South Africa, High Court, Mlambo, the senior, who was the JP in Gauteng, they were asked to declare tobacco and tobacco products, whatever. What was the phrase? I forget what it is. You remember it, you read it. I'm sorry, I've just slipped it in my mind now. Something that was protected, essential products. Now, can you imagine if the judges had acceded to that order at the time? The headlines across planet Earth would have been in every jurisdiction, translated into every language. 3 South African judges say that tobacco is an essential product, or whatever it was called in that. Can you imagine that? I mean, where on earth can you ask a judge to make his or her name silly in the eyes of the world? Don't do it. Then you, as the person asking the judge, you are making a mockery of the process of the rule of law. So that's what I say here. When you, in 37, make your exemption so clear, so limited, so tight, that you know, when the regulator, remember, it's not just Banzi Krula, it's the entire body that looks at it. They say, this is eminently sensible. We grant the exemption. Okay, please go to the next slide. All right, just write it down. I'm not going to deal with this now, section 44. I want to get to section 99, which is my favorite one. Okay, you please note 50, carry on. 53, carry on. Okay, 55 and 56, carry on. 60, codes of conduct. I could wax eloquent on that for ages. They're very important and very necessary. But no, please carry on. 81, proceedings, please carry on. 87, there I just mentioned, just if you drop back to 87, just remember the Pretoria Portland cement case versus I think it was the Minister of Trade and Industry at the time, where there was a search and seizure that was done before the television cameras. Don't do that sort of thing. That's an abuse. Okay, carry on. Next one, 89, just write it down. Next one, 91, write it down. Next one, write it down, 94. 95, obviously important. 97, the right of appeal is very important. Don't forget it. Here we are, section 99. Now, this is the heart of the entire Act, because now you're dealing with how matters have to be dealt with reasonably. And let me just highlight the points that I want you to consider. In the event of a breach, the responsible party, that's the person I usually say has got the hospital pass inside the organization, may raise any of the following. Vis maior. Now, for lawyers, you need to know the difference between vis maior and an act of God, force majeure, and so on. It goes back to to the idea of don't try and get indemnities written into these clauses that put the weight and balance on the weaker party in the contract, because that's really you overreaching your power. You're overreaching. It's not quite an abuse, but it's twilight zone. When you go for the consent, again, there you're looking at something which is where the abuse is often really dangerous, because people do the consents inside other clauses. Drafters and people don't do that. Set aside the consent, make it very, very clear. I would like then for you to understand this clause in the context of the rule of law. If you've got the law correct, but you have used your power to overreach on the law, then that is in the twilight zone. That's in the twilight zone for an abuse of the rule of law. And so I want to give the last point, and here I would speak to the government lawyers, because I know a lot of government lawyers are on this webinar. It's very important to remember that your mandate is in the Constitution and the Acts of Parliament that are promulgated in terms of the Constitution. Your job is service delivery in many levels. And ideally, you must not be outsourcing. You must actually be doing the work in-house. Outsourcing is a double taxation for people. At this stage, I've run out of time. I have plenty of other things to do, but I have been asked to allow questions. So you're welcome to send the questions through, and Fiona will put the questions to me, and then I'll answer as best we can. We have 10 minutes left.
Thank you so much, Nick, for that absolutely interesting presentation. We are going to quickly try to go through some questions. So if anybody would like to pose any, please feel free to put this on our Q&A tab. While we're waiting for the questions, we also would like to run a poll. So please take some time to answer this. That is going to be showing up on your screen. So Nick, in the interim, maybe we can start answering some questions.
Okay, go for it.
Okay, our first question was, how does one apply the POPIA Act in the event that an applicant who is not a member of an NPC requests to view the members and directors lists of the NPC as provided for in section 26(2) of the Companies Act? These lists contain personal information of the directors and members. So it appears that POPIA is in conflict with the Companies Act in this instance.
Correct.
So,
it is, yeah. It's in
so
conflict.
how much info does the NPC then make available at the request in the event of such a request?
Right. Now, it is in conflict, but luckily there is a mechanism to get past, and it's a lovely question. I'll tell you why, because I haven't even spoken about the Promotion of Access to Information Act. That request has to be made via Section 51 of POPIA. In other words, they will have to explain why they need that. So the answer is that person must be referred to POPIA, and POPIA is the answer to protecting that information. If they can say there is a legitimate reason why they need it, they can get it. If they can't get it. So, for example, it's very difficult to get somebody's tax returns. It's not impossible, but you have to explain a legitimate reason why you want to do that. At the moment, their SARS with all due respect, if there's anybody from SARS, is standing outside of the rule of law by saying absolute no. There's no such thing as an absolute. No, generally, there's no such thing as an absolute. Although there is one absolute, taxes and death. That's two.
Okay, our next question then. POPIA versus POPIA, please assist on guidelines on the two acts and practical implications on what acts to follow. And where can you use POPIA as a defense to not supply information?
You use POPIA, well, it depends where you've been asked to give the information. That question is very broad. The answer is there. If you've been asked to give information, which is personal information, by a complete outsider, a complete what we call the third party, that third party has to use the PIA Act to get the information. If you're being asked between contracting parties that you have to share information for a contracting party, then that's inside POPIA, and you will generally have to share it. The real difficult areas in that sharing concern the interface between life assurance companies and medical aid companies, whether or not, and they are busy working on a code, which in due course will come into being. The banks are also working on a code so that they can share information. And then, of course, when the information is required for national security interest, then you have to supply it. And you obviously have to supply it under a court order.
Okay, next question. Someone asks, they were recently requested for information informally from a public body conducting a financial investigation without following the necessary legal process, subpoena or PIA. Is it reasonable to demand that the proper process be followed?
Yes, yes. Now, remember, when we talk about the rule of law is process. That's vital, but it's also the merits. Now, you can use the example I used earlier. When you use process as the Stalingrad defense, where the design is never to get to the merits, then you're abusing it. But if you don't use process, that is a complete abuse of the rule of law. And I remember many years ago, the director of the law review project, a man called Leon Lowe, who's now in the some of the foundation, whatever it's called, he used to say that due process for famous and wonderfully loved people is a luxury, and due process for the person we know is guilty is a necessity. And it tends to follow the money. So somebody is accused of rape, you need due process. Because if the community gets hold of you, you will not have due process. So it depends on the context.
Okay. Next question then, Nick. On a policy, if my client would nominate a beneficiary, do I need to get the beneficiary's consent first before I capture the information of the beneficiaries?
Ooh, that's a left field question. Look, the reason why you're getting the details would be so that you can identify accurately what you're doing, so that they don't give the money to somebody else with the same name. So you do need that information. Out of caution, I would get it. But even if you had it, let me tell you how you can get people's information when they don't know it, but you can do it for a legitimate purpose. say they are a director of a company, you go onto CIPIC, you get their identity number, and then you put that identity number into your document for the beneficiary. Now, you've used public information, you haven't asked permission, but you can justify what you've done because you want that person to receive the benefit. Again, can you see how we've had to go through a fact complex to decide where the answer lies? And unfortunately, POPIA, being principle-based legislation, requires you to do that at every step, which is intellect intensive first, before it's pen intensive. So think first, write later. It's that old thing is think before you ink.
Absolutely. Okay, let's move on to the next question. How do you handle a reference check for a terminated employee who was dismissed for misconduct and the reason for leaving the employee is asked by the potential new employer via the ref check?
That is a classic. That's a chestnut. That's a brilliant question. Now, what you're dealing there with risk management. If you tell the person the truth of why they were dismissed, they are not going to get hired. If you tell the person a falsehood, they might get hired. Now, if you've told them a falsehood and it transpires that the person commits the same offense there, and later they found out that you fired them, you're liable for your misinformation. So in that respect, truth trumps your risk management, because the person who leaves you might sue you for defamation, but they would find it very difficult because it would not fall within the rubric, because you're not disseminating it. You're only answering one question in what is very closely analogous to a privileged circumstance, privileged occasion.
Thank you. Let's go on to the next question. Is the information of offenders in criminal activity protected?
I'm not quite sure what that question is aiming at. Let me tell you where it's not protected. But it was a very funny German case, and I'm not going to mention the name because I've forgotten it. But what happened is that an American citizen who could speak German fluently was fired in the United States as a head of a boarding school because he was a pedophile. He then got himself employed in Germany as the head of a boarding school, but he didn't tell them that he'd been fired for pedophilia. When they found out, they immediately fired him. So yes, in certain circumstances, you've got to be able to know. And I'll tell you where the law is pretty clear about it. If you see a whole plethora of statutes, if you've been found guilty of an offense of dishonesty, you are disqualified from many things, many things. If you're an unrehabilitated insolvent, you're disqualified from many things. So there are times where it's absolutely vital to give that information when you're asked. In the end, honesty is not a policy. Honesty is a way of life.
I love that. And I think that with that, unfortunately, this hour has flown by and we are going to have to now close off the session. But we do want to thank all of you for joining us today, especially you, Advocate T. It was the most informative session. Please do note that we have got some information about all of our POPIA content that is going to be available. And we also would like to have a chance, all of the webinar will be distributed to everybody who has attended. So please don't worry about that. And please feel free to also join our LinkedIn page where you can access all of the webinars that will be pending. So thank you everyone for joining us today. And we hope that you all have a good Wednesday. Thank you all.
Bye-bye.